Firstly, can I thank the Society for having me today, and I guess it's a great sign of the, in particular the President's leadership of the profession, that we're having this conversation in this forum. I guess what I'm doing very briefly could be summarised up by my firm's logo, which is bridging the gap. And I guess to understand that a little bit more granular detail, I should give a bit of background, and I'll try to be brief. I worked as a legal aid teenage work experience student in 1988. Started the Footscray Community Legal Centre when they moved offices in 1991. Having, I guess, had an experience there, a positive experience in I guess, what you'd call social justice law, I guess it grounded me in some really important lessons, which were that your client and the people that you represent, are real people, and ultimately have interests that should be, as best you can, to the limits of the law, prosecuted vigorously. When I finished my articles, which in Victoria was a 12-month process, and I'll come back to that, I moved to Sydney and had a chance meeting with a Sydney-sider who eventually became my wife, Belinda. But my practice areas of back-end and front-end construction were sort of mirrored by what was going on in the construction industry at around that time of the Olympics, which you'll recall involved building road networks, building major facilities. And so, having worked on the largest PPP projects, which is the public-private partnership acronym, I guess I'd call myself a projects lawyer, given that background and experience in big firms. I started a practice in Sydney, which was one of the leading Victorian firms, and became a founding partner of the Sydney practice, which has now become, since then, one of the leading local government firms. So I guess, this step that then led me to big law, back to big law, was a sort of a journey back into, would the international firms be something that I was going to do? I became an equity partner in, I think, the second or third maybe largest law firm in the world, had partners numbering 60 reporting to me directly in areas that I was charged with in terms of government and, of course, infrastructure. I guess I felt the pinnacle of that move when I attended a partners conference in Los Angeles, where over 100 Australian partners, and that's partners, attended together with over 1,500 overseas partners. The hotel couldn't accommodate the number of partners that were present. They had to get a second hotel as well. I guess that, and I guess other experiences along that journey have taught me a number of things, including, I regularly present for the Law Society and UNSW in CLEs. Some things that probably started to refocus me a bit on perhaps where I started my journey back in 1988 or so, and it was back to my clients. And I guess that's the key message that I want to bring, where I've set up a firm which I intend in the next 3 years to be the leading independent projects firm in Sydney, and then a 5-year plan of making that happen around Australia. So what are the issues? The issues as I see them in that, I guess, whole journey from me being in an equity partnership role in a big international firm through to, I guess, starting at what you might call the sole practitioner status, but I'd prefer the specialist practitioner tag. Big law, to me, represented quite a complicated and indeed fascinating journey into the levels of politics, of bureaucracy, I guess the excitement of international, and all of the things that George said, sadly, in terms of distress. It's not just disruption that's causing, I think, the tectonic shifts we're seeing, and not just the international firms arriving, but it's the sort of examples that I guess I found where firms are a very fragile ecosystem of that size. You have a minder, you have a grinder, and then a finder. And not every lawyer is skilled and adept at doing each of those three very distinct things: minding clients, going out and finding new clients, and then obviously grinding away at the work those clients give you. I guess what I found is that sometimes the firms can behave quite inflexibly, in fact, many times, and probably also, maybe a little worse than that, somewhat irrationally. I think what I decided at this 20-year juncture in my career was that I could probably make a bit of a difference. So then you flip to the discussion about, well, what about all those medium firms that are there, and what about the sort of smaller partnerships? And I really did, having had one or two experiences in that regard, as I said, founding one of the ones that have become one of the leading medium firms, I had my reservations, and they're around things like quality and whether effectively you're trying to create a big law firm in a different but I guess the same way, and whether if you try to become the Joneses, you might overreach and become what in fact you are not. So I guess that conundrum had me thinking, well, what would my clients do? Which leads me to what I'm doing in my firm, which is really becoming an outsourced firm. And that's something which in the construction industry is commonplace. The contractual chain has a principal, maybe then a main entity that is dealt with, say a barrister or even a fellow colleague that's expert in intellectual property law or other areas. The networks that I've generated over those 20 years have sort of led me to a path of understanding partners that have maybe made a similar decision to mine or even haven't. And so when you can work with people and outsource the things that you're not expert at, what you get is the best of both worlds for your clients. You get you for their coming to you as for your expertise, but you get the flexibility to be able to use who's best for the job. I guess it's a bit scary for people who haven't delegated in large numbers and on large matters like I'm handling at the moment. But as you start to see, 1,500 or more partners work together, you start to see, well, it's actually not that different to what goes on out there in the real world. In fact, I've heard it said often that really the big firms and big law these days really only operate as a brand with a group of individual practitioners or even sole practitioners, to use that phrase, the constituent parts of that whole. So I guess I decided that what I would do was look at, to use George's phrase again, the Uber way of doing things, and that's really, I think, a very flexible, a very, client-friendly, user-friendly, if you want to call it that, way of dealing. And so there were really three things that I came up with. They were the idea of flexible employment, because as I started to recruit, and I've recruited I don't know how many thousands of lawyers over the 20 years I've been involved in law firms. My view is that the sort of 9 to 5 economy is almost on the way out, that flexibility, both for reasons of equity and for reasons of, I guess, simple technology and client common sense are with us. And so the ability to work with people who might be flexible and want to have 2 days of work only, not have to have them there and feel like they have to be there 5 days a week was a big issue for me, and that's something I'll return to later. Advanced technology, the products that are out there, and I can say this with a little bit of authority, having started an IT business in 2002, which has become very successful. The technology that's available at a very, very low cost rate is quite extraordinary. And to give a quick example of that, Microsoft's off-the-shelf products can be hired for about $17 a month, and if you ring them up like I did, they'll give you a year free. So that sort of powerful technology that used to be out of the reach of anybody is sort of gone now, and it's available. And I guess the third one, and this is my favourite, perhaps a bit of a joyous topic for probably the reason I'm here today for the person who asked me to attend, because I showed them the office. It's a paperless office. And I could never quite see how it was going to work for me until I decided not to buy a printer. And that fateful decision was a very good one, because when you don't print things and you can't print things, you're paperless. What you do, of course, is you use the external providers. You outsource. You go to Law and Order or other reputable organisations, and frankly, even Officeworks. If you do it the right way, document storage costs are gone. You create a more efficient way of working. And of course, in my view, recently I had a meeting with senior counsel. Paper was requested, paper was printed and provided. Of course, when people started asking, where's that witness, or what does that witness say, on my laptop, which is right in front of me here, which is my office, I found things within about 3-5 seconds, and papers were still being sort of sorted through and trying to sift through. So I guess that really did vindicate to me the paperless is the way forward. I guess sort of to quickly finish up on my introductory comments, the challenges, I guess, that all of what I've talked about today presents really to me is in 3 areas. The international angle. I mean, you don't even need to look further than the Brexit decision to see that unions of an international variety can be very, very complicated. I guess also more closer to home, party politics in even choosing a say a Prime Minister might be something that's difficult as well. What it does conclude to me is certainly making dysfunctional organisations functional, and I'm talking about here the partnership model, is not easy, and I think is something which is going to be a great challenge for these firms as we go forward, particularly as differential profit rates come in, differential culture comes in, and of course, let's look at what the accounting firms have done. George tells me it was a 26-year journey they've been on. I believe that it could well be as long as that for the law firms, if not longer, and I do sincerely hope in 26 years' time I'll be on a beach with my wife, not having to give evidence again. The local firms, I guess, I say that they've done very well. I think the firms, in fact the President's firm, I should say, having been a former colleague of his, was a great example of a firm deciding maybe not to go international. I know there's international offices, but I'm talking a tie-up, I mean. But then profiting in areas of government work and other local-based work. I think that's a big issue and not to be underestimated. And finally, specialisation. I said earlier, I think what the Law Society could probably do is do two things that might be useful. It's reinventing that, I guess, to some extent, negative phrase sole practitioner to become, as I said earlier, specialist practitioner. Now I know there's a society's credited scheme and so forth, but the way I see firms operating in future is that clients will choose who they know is good at a particular area and go to them for their specialty, whether they've got the badge of the society or not, which I think is a great initiative. The second thing I think is that clients are not going to pay for a paralegal or a law clerk to sit in a registry office for 4 hours anymore, like is the case at the moment. When young lawyers get work, and I've established a panel of young lawyers that range from people who want, who have other commitments and want only part-time work, through to up-and-coming students who. When you look at some of the marks coming out these days, it's just a frightening thing of how competitive these students are, and not only that, how good they are. They're holding down 3 and 4 jobs, becoming managing directors of PTY companies before they're 20, and then of course cranking out A's and B's, which if I can pick up 3 or 4 of those students, have them on my book. Really, I'm operating like I was in the big international firms, just without all of the politics and the other nonsense. So with all of that, I guess I would say one final thing. It's that the old article system, which I've almost brought in de facto terms by having a panel of paralegals, they're people who I'll care about their careers. I'll actually look at them as a long-term proposition. Hopefully when they finish law, they'll be available to come on and be more full-time if that's what path they take. I think what we're lacking a bit at the moment, and it's that vexed issue of how many students are coming out versus how many jobs are there, is a bit of flexibility. You don't need to give these students, in my view, and they're telling me this, so I guess I'm listening to what I'm hearing, full-time roles. In fact, many of them don't want it. They want to do their studies well, they want to get good marks, and they're quite comfortable working at home. They'll take their work, if you give them a brief like you would a barrister, to university, and in the hour or two they've got between events, they'll finish it. I've been very, very excited about what I've been able to achieve in the last sort of 4 months, and it's been 4 months, so stay tuned. And I'm also very excited about some ideas it's given me about the future of how firms can even be better than they already are. So with all of that, thank you, and I'm happy to take questions.
Thank you, Keith. You seem to have been at the eye of change for many, many years. Where do you see the future for the legal profession?
Look, I think it's got to be the outsourced model, because it's a client demand. Clients have got so much option, and we've heard today from George about the accounting firms. They're going to have and do have law firms of equivalent, if not better sometimes, standard that exists within the law profession. And I say that not to say that I agree with that model. To this extent, I've created that model myself without having to have a formal tie, say, become a beholden law firm to an accounting firm. And I say that for this reason. If your networks are such, like I guess mine are after 20 years in the law, that you can bring in an accountant that does damages claims or is really good with management books and records and so forth, you don't need to have that formal multidisciplinary model. You can create it informally.
I was interested to hear your comments about sole practitioners becoming specialist practitioners. What, in your view, does that mean for the generalist sole practitioner?
Yes, look, if they don't do what I say I think they should do, and of course, please understand, I look at this through the lens of an infrastructure lawyer working on major projects that I guess demand and command expertise. But if they don't, I guess, to be blunt, change with the times and be adaptable enough to be able to brief out or bring in expertise where it's necessary, they'll go the way of, I guess, lots of different general practitioners where, as I said earlier, they might become jack of all trades and master of none, and then clients will just say, you know what, we've got so many other solutions here, let's go with the one which is going to give us the best outcome. You're sure all experience the scenario of going to a professional of any kind, be it an accountant, lawyer or otherwise, and if you see the expert that charges you $1,000 for an hour, you might spend $5 at someone charging you $300 an hour. So, at the end of the day, it's about cost and efficiency as well as expertise.
Okay. Mark?
One of the questions I wanted to ask you was, because you've worked in a number, I guess, of different types of firms, is it fair to say that with the sort of the changes in technology and outsourcing that even in a small firm, it's now possible to act for the same clients and do the same matters as a large firm does? Or are there some areas where you would say, look, you really do need, body count to be able to take on like a really large piece of litigation, for instance? Is there any areas where you still need the sort of big law?
Look, I think it's the former, not necessarily always the latter, and I'll explain it this way. I recently filed a claim which was over $14 million, which if I'd filed in any other firm I'd operated in, including the big firms I've been in, would be considered a very large claim. I did it by engaging the paralegals in my panel, engaging appropriate senior and junior counsel, and then using those resources. Now, you've got to realise, and I don't mean that disrespectfully, I mean to say it's important to realise that the barristers out there can often be, obviously, ex-firm, big law firms themselves. From a simple cost point of view, if you look at it, would you, if your clients go to, say, a second-year lawyer who's charging you $400 or $350 an hour, or would you go to a barrister that's junior, senior, junior, who's been a senior associate, say, or somewhere at one of the big firms, Allens and Minters or whoever, and charging you $300 an hour? I mean, it answers itself. So I guess the short point is that I tend towards the former. Having said all of that, I don't mean to gloss over, and I do know the intricacies of the large firms and how they operate and what they're good at. They're very good at things that are international transactions. They're very good at things that need other offices, for instance. What I think they're not good at, certainly as far as law firms go, in my observation, were coordinating all of that. So to answer your question on the second point, I would say that if a client came to me and wanted to do, say, a transaction in Dubai, and I have exactly had that question, in working with one of the local lawyers there, I can probably do as good, if not maybe even better job than some of the big internationals, and I can certainly say for a more efficient, cost-effective way. So I guess that whole tag of sole practitioner, I think we have to lose it, because if we don't lose it, it will continue to be the thing that, with respect to them, the big law firms have done. And everybody thinks big's better. Well, I can tell you, I've seen it. It's not always the case.
Just going back to the use of paralegals, or I assume the paralegals are law students that you would use, or are they
all pre-admission, currently getting admitted, law students, non-law students as well? I mean,
and what's your observation about their technological skills? Do they have technological skills? Do they acquire them working for you? Are the universities equipping them well to work within a firm such as yours?
much better than any of us, President. I think, in fact, I'd almost go to say my 12-year-old daughter's probably much better than I am at technology, and I know a bit of it. What I did to I guess, get to the chase on that question seriously was I did about 20 interviews of paralegals before I made hires, which, like I said earlier, were around 5. I thought that I might have to spend a bit of time explaining how my firm operates and how, I guess, we embrace outsourcing and we embrace technology. Wasn't an issue. Everybody understood it. In fact, I had that many students say to me, wow, that's the sort of firm I want to work with, whether they were saying that or not. They've all accepted offers I've made. It's just an eye-opening experience, actually. In fact, it's after 20 years in the law, you seriously look back at your own career and say, how would you have gotten a job with this sort of environment? It's highly competitive. Like I said earlier, there's students doing 4 and 5 jobs and starting companies and businesses and creating apps and doing the sort of things that are very, very innovative. And I actually think, we could all take a good leaf out of their books, quite frankly, because, as I said earlier, the QC who flailed around in the paper, having been set up on the system to find things at my fingertips within an instant, frankly, he's just wasting everybody's time, flailing around in paper. Why would you do that when you can just press a couple of buttons and up it pops? Forcing yourself to do it is a different story. Forcing yourself as a practitioner after 20 years to teach an old dog in me a new trick, that was a challenge. It's not a challenge to get the law students to help you understand it.